Most people freeze when an officer's hands cross the line during a pat-down, thinking silence keeps them safe. It doesn't. That silence becomes consent in court, and you lose before the fight even starts. I'm going to show you exactly how to document, respond, and protect yourself when a search becomes inappropriate. Number 1. Recognize what inappropriate touching actually is under the law. The Fourth Amendment protects you from unreasonable searches, but most people don't understand where reasonable ends and violation begins. A lawful pat-down, what courts call a Terry frisk, allows an officer to feel the outer clothing for weapons. That's it. Weapons. The officer's hands should move quickly over your outer garments, checking for hard objects that could be used to harm them. The search must be brief, non-intrusive, and strictly limited to detecting firearms, knives, or similar dangerous items. Inappropriate touching occurs when an officer exceeds this narrow scope. If hands slide under clothing without probable cause for arrest, that's a violation. If an officer gropes, squeezes, or manipulates areas of your body unrelated to officer safety, that crosses into Fourth Amendment territory and potentially criminal assault. If the search continues after it's clear you have no weapons, it's no longer justified. Courts have consistently ruled that officers cannot use a Terry frisk as a fishing expedition for evidence or as an opportunity for sexual gratification. The Minnesota versus Dickerson case established that officers can seize contraband discovered during a lawful frisk only if its identity is immediately apparent through touch without manipulation. If an officer must squeeze, slide, or manipulate an object to identify it, they've gone beyond the permissible scope. This precedent matters because it draws a clear constitutional line. Gender also plays a role here. While there's no absolute legal requirement that same-gender officers conduct searches in all circumstances, opposite-gender searches of sensitive areas without legitimate cause raise additional red flags. Many department policies require same-gender searches when possible, and violations of these policies strengthen civil rights claims. Number 2. Verbally object in real time using specific legal language. Your immediate verbal response creates the evidentiary foundation for everything that follows. Silence implies consent in many legal contexts, and officers know this. You must vocalize your objection clearly, calmly, and repeatedly. Say exactly this: I do not consent to this search. You are touching me inappropriately. I am not resisting, but I verbally object to this contact. This phrasing accomplishes 3 critical objectives simultaneously. First, it explicitly revokes any implied consent, which matters because some courts have found that cooperation with a search suggests consent. By stating you do not consent, you eliminate that interpretation. Second, you're creating a verbal record that witnesses, body cameras, and dash cameras will capture. This evidence becomes invaluable when the officer's report contradicts your experience. Third, you're establishing non-resistance while maintaining your rights. This is crucial because any physical resistance, even pulling away, can escalate to resisting arrest charges or give officers justification for greater force. Repeat this statement throughout the encounter if the inappropriate touching continues. Each repetition strengthens your record. If the officer responds by saying they have the right to search you, reply, I understand you are conducting a search, but I do not consent to the manner in which you are touching me, and I am stating for the record that I believe this contact is inappropriate. Never physically resist or pull away. Keep your hands visible. Do not touch the officer. Your resistance must be verbal only. Physical resistance transforms you from victim to perpetrator in the legal system, and officers can use any physical contact from you to justify arrest or force. Number 3. Immediately request a supervisor and state your reason. Once you've verbalized your objection, escalate by requesting supervisory presence. Say, I am requesting a supervisor respond to this location immediately. I believe this officer is conducting an inappropriate search. This request serves multiple functions in protecting your legal position. First, it creates an additional witness to the scene. Supervisors carry more institutional weight when they document incidents, and their reports are often given more credibility in internal affairs investigations and legal proceedings. Second, it signals to the officer that you understand your rights and intend to pursue accountability. Officers who are acting inappropriately often modify their behavior when they know supervision is en route. Third, it starts the formal complaint process even before you leave the scene. The supervisor must document your complaint in their report, creating an immediate record that cannot be backdated or dismissed. When the supervisor arrives, do not assume they will be impartial. Repeat your objection clearly. This officer touched me inappropriately during a search. I did not consent. I want this documented in writing, and I want to file a formal complaint. Request the supervisor's name and badge number. Many supervisors will try to minimize the situation or suggest you're overreacting. Stand firm. Say, "I understand this may seem minor to you, but I am formally stating that I was touched inappropriately. I want this documented, and I will be filing a complaint." Do not let them talk you out of making a report. They may say things like, "These things happened during searches," or "The officer was just doing their job." Your response should be, "That may be your assessment, but I am telling you what I experienced, and I have the right to have this documented and investigated." If the supervisor refuses to take your complaint or document the incident, state clearly, "I am noting for the record that I requested to file a complaint and was refused. I will be filing my complaint directly with Internal Affairs." This statement puts them on notice that their refusal to document will itself become part of your complaint. Number 4. Document every detail immediately while memory is fresh. The minutes and hours following an inappropriate search are critical for evidence preservation. Your memory will never be clearer than it is right now, and details that seem unforgettable in the moment will fade surprisingly fast. As soon as you are safely able, create a comprehensive written account of the entire encounter. Start with the basic facts: date, time, exact location. Be specific. Don't just write Main Street. Write southwest corner of Main Street and 5th Avenue in front of the Chase Bank branch. Note weather conditions, lighting, and how many people were around. These details establish scene credibility. Then document the officer's information. Name if you got it, badge number if visible, physical description including approximate height, build, hair color, uniform details, and any identifying marks like tattoos or scars visible below the short sleeve uniform line. Now describe the encounter chronologically. Write what led to the initial stop. What reason did the officer give, if any? What were you doing immediately before the stop? Then detail the search itself. This is where most people struggle because the experience is traumatic and uncomfortable to relive. Push through that discomfort. Write exactly where the officer's hands went. Be explicit and clinical. The officer's hand moved up my inner thigh to my groin area and applied pressure. The officer squeezed my breasts. The officer's fingers went inside the waistband of my pants in the back. These specific descriptions are not gratuitous. They are evidence. Courts need to understand exactly what occurred, and vague descriptions allow for reinterpretation. Document what you said and what the officer said. Quote as precisely as you can remember. If the officer made comments about your body, write them word for word. If you objected and the officer dismissed your objection, capture that exchange. Note whether other officers were present and what they did. Did they participate? Did they watch? Did they turn away? Each officer's action or inaction matters for establishing department culture and supervisory liability. Write down the names and contact information of any witnesses. If people were nearby, describe them even if you don't know their names. Hispanic male, approximately 30 years old, wearing a red jacket, standing near the bus stop shelter. This allows investigators to potentially locate witnesses later. Include your emotional and physical state. Were you shaking? Did you cry? Did you feel pain? These reactions are evidence of the encounter's impact. Finally, photograph any physical evidence. If the search left marks, bruises, or injuries, photograph them immediately with timestamps. If your clothing was damaged or disheveled, photograph that too before changing. Number 5. Obtain all available video evidence within critical timeframes. Video evidence is the most powerful tool you have, but it's also the most perishable. You must act quickly because deletion, loss, and recording over happen constantly, sometimes accidentally and sometimes deliberately. There are multiple potential video sources, and you need to pursue all of them simultaneously. First, body-worn cameras. If the officer was wearing a body camera, it likely captured the encounter. Most jurisdictions have laws requiring preservation of body camera footage when complaints are filed. File your complaint immediately to trigger these preservation requirements. Then submit a formal public records request for all body camera footage from all officers present at the scene. Be specific about the date, time, location, and incident. Many states have laws requiring release of body camera footage within specific time frames, often 30 to 60 days, though some allow longer delays or redactions for ongoing investigations. Second, dash cameras. If the encounter occurred near patrol vehicles, dashboard cameras may have captured video or audio. Request dash camera footage from all vehicles on scene. Third, surveillance cameras. Look around the area where the encounter occurred. Are there businesses nearby? Traffic cameras? ATMs? Parking lot cameras? Within 24 hours of the incident, visit nearby businesses and request that they preserve surveillance footage from the date and time of your encounter. Many businesses automatically delete footage after days or weeks. Provide them with a written request including the specific date, time, and location. Follow up with a formal written request via certified mail if necessary. Fourth, witness cell phone video. If people were nearby during the encounter, some may have recorded it. If you can identify witnesses, ask if they captured video and request copies. Social media is also a potential source. Search location tags and hashtags related to the area where the incident occurred. Someone may have posted footage without realizing its significance. Fifth, police station cameras. If you were transported to a station after the encounter, there may be additional footage of your arrival, statements you made, or the booking process. Request all video from the station for the relevant time frame. When requesting footage, use formal public records request procedures. Many jurisdictions have specific forms and requirements. Send requests via certified mail with return receipt so you have proof of delivery. If requests are denied or ignored, consult an attorney immediately about filing a court order to compel production. Every day that passes increases the risk that footage will be destroyed, overwritten, or lost. Number 6. Seek medical evaluation and create a medical record. Even if you don't believe you suffered physical injury, seek medical evaluation as soon as possible after an inappropriate search. This serves multiple legal and personal purposes. First, a medical examination creates an objective, contemporaneous record of the incident. Medical records carry substantial weight in legal proceedings because they are created by neutral third parties for treatment purposes, not litigation. Go to an emergency room, urgent care center, or your primary care physician. Tell the medical provider exactly what happened. Do not minimize or sanitize the experience. Say explicitly, "I was searched by a police officer who touched me inappropriately." Describe where you were touched and how it made you feel. If you are experiencing emotional distress, anxiety, difficulty sleeping, or other psychological symptoms, report those as well. The medical provider should document your account in your medical record along with their physical findings. The examination should include documentation of any visible injuries, marks, bruising, or signs of trauma. Even if you feel fine, sometimes injuries emerge hours or days after an incident. Bruising in particular may not be immediately visible. Photograph any injuries yourself as well, but having a medical professional document them adds credibility. If you are experiencing psychological distress, ask for a referral to a mental health professional. Counseling serves both therapeutic and evidentiary purposes. A therapist's notes documenting how the incident affected you can support claims for emotional distress damages. Medical records also establish a timeline that is difficult for the defense to challenge. The records will show you sought treatment immediately after the incident, which corroborates that something serious occurred. Delayed reporting raises questions about credibility in many people's minds, fairly or not. Immediate medical attention eliminates that question. Do not worry about the cost if you lack insurance. Many victims' compensation programs will cover medical expenses for crime victims, and emergency rooms must provide screening examinations regardless of ability to pay. You can address billing issues later. The priority is creating the record while evidence is fresh. Number 7. File a formal complaint with multiple oversight bodies simultaneously. Your complaint must be filed through every available channel to maximize accountability and create redundancy in the record. Start with the police department's Internal Affairs Division. Every agency has some mechanism for civilian complaints, though they may not advertise it prominently. Call the non-emergency line and ask for the Internal Affairs or Professional Standards Division. Request the complaint process and forms. Many departments now allow online complaint filing. When filing with Internal Affairs, provide your detailed written account, any supporting documentation, and your contact information. Request a case number and the name of the investigator assigned to your complaint. Understand that Internal Affairs serves the department, not you. Their investigation may or may not result in discipline, and you likely will not be informed of the outcome due to officer privacy rights. However, filing creates an official record that becomes discoverable if you file a civil lawsuit. Simultaneously file complaints with external oversight bodies. Many jurisdictions have civilian review boards, police commissions, or independent oversight agencies that investigate misconduct complaints separately from Internal Affairs. These bodies vary dramatically in their power and effectiveness, but filing with them creates an additional record and applies political pressure. Search for your jurisdiction's civilian oversight mechanism online or call City Hall to ask. File a complaint with your state's Attorney General or law enforcement licensing body. Most states have agencies that certify and regulate police officers. Serious misconduct can result in decertification, meaning the officer loses the ability to work in law enforcement anywhere in the state. Sexual assault during a search is exactly the type of conduct that can lead to decertification. File a complaint with the U.S. Department of Justice Civil Rights Division. Federal law prohibits law enforcement officers from violating constitutional rights under color of law. While the DOJ receives thousands of complaints and investigates only a fraction, Your complaint contributes to pattern and practice data. If the DOJ identifies systematic problems in a department, your complaint becomes part of that evidence. Request copies of all complaint confirmations, case numbers, and correspondence. Create a file with everything organized chronologically. This documentation demonstrates that you pursued every available administrative remedy, which can be important if you later file a lawsuit. Some civil rights claims require exhaustion of administrative remedies before proceeding to court. Number 8. Consult a civil rights attorney before speaking to investigators. Once you have filed complaints, investigators may contact you for interviews. Before you participate in any investigative interview, consult with an attorney who specializes in civil rights and police misconduct cases. This is not a sign of guilt or dishonesty, it is strategic legal protection. Investigators, even from civilian oversight bodies, are trained in interview techniques designed to elicit information and test credibility. They may phrase questions in ways that seem to minimize your experience or suggest you misunderstood what occurred. They may point out inconsistencies between your statements and the officer's report. Without legal guidance, you may inadvertently make statements that weaken your legal position or create impeachment material for trial. A civil rights attorney can advise you on what to expect during the investigation, how to answer questions effectively, and what information to provide or withhold. In some cases, an attorney may recommend not participating in the internal investigation at all, particularly if criminal charges are possible. Anything you say to internal investigators can potentially be shared with prosecutors or used against you in other contexts. Finding the right attorney matters. Look for lawyers who regularly handle Section 1983 civil rights cases against police. These cases require specialized knowledge of constitutional law, qualified immunity doctrine, municipal liability, and the complex procedural rules governing suits against government entities. Many civil rights attorneys work on contingency, meaning they take a percentage of any settlement or judgment rather than charging hourly fees. This makes legal representation accessible even if you cannot afford to pay up front. During the initial consultation, which is often free, the attorney will evaluate the strength of your case. They will consider factors like the availability of evidence, the clarity of the constitutional violation, the extent of your injuries and damages, and the defendant's likely defenses. They will explain qualified immunity, which protects officers from liability unless they violated clearly established constitutional rights that a reasonable officer would have known. They will discuss potential damages, including compensatory damages for physical and emotional harm, punitive damages if the conduct was especially egregious, and attorney's fees. If the attorney agrees to take your case, they will handle all communication with investigators and the department. This ensures consistency in your story and prevents you from being manipulated or pressured into dropping your complaint. The attorney can also advise whether to file a civil lawsuit immediately or wait for the criminal and administrative investigations to conclude. Each approach has strategic advantages depending on your specific circumstances. Number 9. Understand the difference between civil, criminal, and administrative remedies. Your complaint can proceed on 3 separate tracks simultaneously: criminal prosecution of the officer, civil litigation against the officer and department, and administrative discipline through internal affairs. Each track has different standards, procedures, and potential outcomes. Understanding these differences helps you manage expectations and make informed decisions. Criminal prosecution means the officer is charged with a crime like sexual assault, battery, or official misconduct. Criminal cases require proof beyond a reasonable doubt, the highest legal standard. The decision to prosecute rests entirely with the prosecutor, not with you. You are a witness, but you do not control whether charges are filed. Most inappropriate searches by police do not result in criminal charges because prosecutors are reluctant to charge officers. The conduct may not clearly meet all elements of a criminal statute, and proving criminal intent beyond a reasonable doubt is difficult. However, egregious cases involving clear sexual assault do sometimes result in criminal charges. If the prosecutor declines to file charges, that does not mean your complaint was false or unimportant. It means the prosecutor did not believe they could meet the beyond reasonable doubt standard. Civil litigation means you file a lawsuit seeking monetary damages. The most common basis for such lawsuits is 42 U.S.C. Section 1983, which allows people to sue government officials who violate their constitutional rights. Civil cases use the preponderance of the evidence standard, which is much lower than beyond a reasonable doubt. You must prove it is more likely than not that the violation occurred. Civil cases can proceed even if no criminal charges were filed. You can sue both the individual officer and the municipality, though suing the city requires proving municipal policy or custom caused the violation, not just that one rogue officer acted badly. Civil litigation can result in compensatory damages for medical expenses, lost wages, pain and suffering, and emotional distress. If the conduct was particularly outrageous, punitive damages may be available to punish the officer and deter future misconduct. Civil rights cases also allow recovery of attorney's fees from the defendant if you prevail, which makes it possible for attorneys to take cases on contingency. Administrative discipline occurs through the police department's internal affairs process. Possible outcomes range from no action to verbal or written reprimands to suspension, demotion, or termination. You typically will not be informed of the outcome due to officer privacy rights and union contract provisions, though some jurisdictions have reformed their laws to allow greater transparency. Administrative investigations use the lowest standard of proof, sometimes called preponderance of evidence or substantial evidence. Even if the internal investigation sustains your complaint, that does not guarantee meaningful discipline. Many officers with sustained misconduct, complaints remain on the force due to union protections, arbitration, and weak department leadership. You should pursue all three tracks simultaneously if possible. Each track provides different forms of accountability and serves different purposes. Criminal prosecution vindicates society's interest in punishing criminal conduct. Civil litigation compensates you for harm and creates financial incentives for departments to improve training and supervision. Administrative discipline protects the public by removing dangerous officers from the streets. Number 10. Preserve your own credibility by avoiding social media and public statements. After experiencing police misconduct, your natural impulse may be to share your story publicly, post on social media, or speak to reporters. Resist this urge until you have consulted with an attorney. Public statements before your case is resolved can severely damage your legal position. Everything you post on social media becomes evidence. Defense attorneys will scour your accounts looking for inconsistencies, exaggerations, or statements that undermine your credibility. A post that says "worst day of my life," followed 2 days later by smiling vacation photos, can be used to argue you were not really traumatized. A detailed Facebook post about the incident that differs even slightly from your official complaint statement will be used to impeach you at trial. Angry posts calling for the officer to be fired or imprisoned can be characterized as vindictiveness that motivated a false complaint. Even posts that seem harmless can be weaponized. Photos showing you drinking alcohol can be used to suggest you were intoxicated during the encounter, even if the photos were taken months later. Posts about financial problems can be used to suggest you filed a false complaint hoping for a settlement payout. Posts expressing anti-police sentiments, even general criticisms of police brutality, can be used to suggest bias against the officer. Beyond your own posts, comments and tags from friends can create problems. Someone tagging you in a post mocking police, even if you didn't write it, can be used against you. Set your social media accounts to private and restrict who can tag you or post on your timeline. Better yet, consider deactivating your accounts temporarily until your case is resolved. Anything posted online exists forever, even if you delete it later. Screenshots, archives, and cached versions can be recovered. Media interviews present similar risks. Reporters may seem sympathetic, but they are not your advocates. They may edit your statements for drama or brevity in ways that distort your meaning. Once your words are published, they become impeachment material. If you later testify differently, even if your testimony is more accurate than the edited interview, the defense will use the interview to argue you changed your story. Wait until your legal case is resolved before speaking publicly. Once a settlement is reached or a verdict is entered, you are free to share your story, if you choose. At that point, public attention can serve a valuable purpose by raising awareness and pressuring reforms. But during the pendency of your case, silence is strategic. Number 11. Prepare for the emotional and psychological toll of pursuing accountability. Pursuing a complaint against police is not like other legal processes. It is uniquely adversarial and psychologically taxing in ways that you need to anticipate. The system is designed to protect officers, and you will encounter resistance, skepticism, and hostility at nearly every stage. Internal affairs investigations often feel like victim-blaming exercises. Investigators may question why you were in that location, what you were wearing, whether you were intoxicated, or whether you misunderstood what was happening. These questions can feel like accusations that you caused or invited the misconduct. Prepare yourself mentally for this treatment. It is not a reflection of your credibility, it is how these investigations function. The process takes years. Civil rights. Litigation typically takes 2 to 5 years from filing to resolution. During that time, you will be required to relive the incident repeatedly through depositions, interrogatories, interviews, and eventually trial, if the case does not settle. Each retelling can be re-traumatizing. You will be cross-examined by defense attorneys whose job is to destroy your credibility. They will ask invasive questions about your personal history, mental health, sexual history, and criminal record, all in an effort to portray you as unreliable or motivated by improper reasons. You may face retaliation. While illegal, retaliation against complainants occurs. You may experience increased police attention in your neighborhood, pretextual traffic stops, or harassment of family members. Document any suspicious police encounters after filing your complaint. If you believe retaliation is occurring, report it immediately to your attorney and to the oversight bodies where you filed complaints. The financial stress is real. Even if your attorney works on contingency, you may lose work time for interviews, depositions, and court appearances. You may have medical expenses or therapy costs not fully covered by insurance. You may feel pressure to settle for less than your case is worth because you need money now. Your attorney can help you think through these practical considerations, but ultimately the decision to continue or settle is yours. The emotional impact of fighting for accountability often requires professional support. Consider working with a therapist experienced in trauma, particularly trauma related to authority figures or sexual assault. Support groups for survivors of police violence exist in many communities and online. Connecting with others who have been through similar experiences can reduce the isolation and provide practical advice. Understand that you may not get the outcome you hope for. Officers are rarely convicted criminally. Civil cases settle for amounts that never feel adequate to compensate for the violation. Administrative discipline is often minimal or non-existent. These disappointing outcomes do not mean you were wrong to pursue accountability. Every complaint creates a record. Every lawsuit costs the city money and generates scrutiny. Every sustained finding contributes to a pattern that may eventually result in meaningful reform or an officer's termination. Your case may not change everything, but it changes something. Number 12. Know the statute of limitations and act within required timeframes. Legal claims have strict deadlines called statutes of limitations. If you miss these deadlines, you lose your right to sue permanently, no matter how strong your case. The deadlines vary by jurisdiction and type of claim, so you must act quickly and consult an attorney to preserve your rights. For Section 1983 civil rights claims, most states apply a 2- or 3-year statute of limitations, borrowed from state personal injury law. However, some states have shorter periods, and the clock usually starts running from the date of the incident, not from when you discovered the harm or filed a complaint. This means you could have as little as 1 year to file a lawsuit in some jurisdictions. Claims against federal officers under Bivens have different and often shorter deadlines. Before filing a lawsuit against a municipality, many jurisdictions require filing a notice of claim within a very short time frame, often 60 to 180 days. This notice must describe the incident and your injuries and put the city on notice that you intend to sue. Failure to file this notice within the deadline often bars your lawsuit entirely, even if the general statute of limitations has not expired. These notice requirements are strictly enforced. Courts rarely grant extensions. Criminal statutes of limitations vary by state and by the specific crime charged. Sexual assault charges typically have longer limitations periods than simple battery, and some states have eliminated limitations periods for certain sexual offenses entirely. However, you have no control over whether prosecutors file charges, so the criminal statute of limitations is less relevant to your decision-making than civil deadlines. Administrative complaints often have their own deadlines. Some departments require complaints to be filed within 30 days or risk being deemed untimely. While these internal deadlines may not be absolute bars to investigation, they provide the department with an excuse to dismiss your complaint without full investigation. File as quickly as possible to avoid this issue. The complexity of these overlapping deadlines makes early consultation with an attorney critical. Do not wait to see how the internal affairs investigation or criminal investigation unfolds before speaking to a lawyer. By the time those processes conclude, you may have missed civil filing deadlines. An attorney can file a civil lawsuit to preserve your rights while other investigations continue. This is your mission now. You have experienced something that should never happen in a free society. Police are granted extraordinary power, and with that power comes absolute responsibility to respect constitutional boundaries. When officers violate those boundaries through inappropriate touching during searches, they betray the public trust and commit acts that are both unconstitutional and potentially criminal. Your decision to pursue accountability is not about vengeance. It is about justice, deterrence, and reform. Every complaint filed, every lawsuit pursued, every officer disciplined or terminated sends a message that this conduct will not be tolerated. You are not just protecting yourself. You are protecting the next person who would have been this officer's victim. Stand firm, document everything, and pursue every available remedy. This is how change happens.